Andrew, welcome to Constituting America's Constitutional Chats podcast. And please tell us a little bit about the Fifth Amendment. You had tweeted, few people know just how much it protects. Right. And we are excited to hear all about that. So I'm going to turn it over to you.
And I appreciate that, Kathy, because it ties into a couple of different things that you were just talking about in my bio, namely the regulatory issues, because the regulatory process is governed by the due process prohibitions in the Fifth Amendment. We're going to get into that. I think it's important for folks to, because folks think about the Fifth and they think about the right against self-incrimination, people who plead the Fifth. And I want to start off, and Aubrey, if you can pull up the Fifth Amendment itself, because I'm going to read it for those of you who don't have it in front of you, because you're going to have it in front of you, and you're going to see a theme here. But here's the Fifth Amendment: no person shall be held to answer for a capital or otherwise infamous crime unless on the presentment of or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, or when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. And you'll notice that in all of this, it's essentially divided into two sections. You have the sections dealing with criminal law and the constraints on government in terms of how crimes get prosecuted and tried, and the defense of those who are accused. Leading into the next segment is the due process clause. We're going to spend a lot of time talking about that. And then you have the takings clause, and we'll go through all five of those. I'm going to tell you at the outset. So the Fifth Amendment is one of my favorite amendments, if we can have favorite amendments. I've spent a lot of time over the years working with it. I'm going to spend more time today probably talking about the due process clause and the takings clause, because those are really areas that I have the greatest expertise. But we could talk a little bit about the criminal sides of this, and I'm obviously going to be open to any questions there. So just by history, so you understand it, obviously part of the Bill of Rights, created in 1789, ratified in 1791. And what's interesting about the Fifth Amendment is that while the text is different and the order of the clauses is different, for instance, the right for a trial by grand jury or to have an indictment presented in a trial by grand jury, that was originally in Madison's draft at the very end. But the core principles that are laid out in the Fifth Amendment were all laid out in Madison's original draft. They're all contained in the final version of the Fifth Amendment, albeit with different text, different wording, and in a different order. And more importantly, they are in many ways a codification of what are called common law principles. So these are principles of general legal applicability that predated America and sort of existed alongside the statutory British law, the so-called common law. So the idea of the indictment, we'll get more into that. But then the issues of process and the rights of individuals vis-a-vis the government in terms of how private property can be taken. So let's get into it and what the clauses are. So there are five of them, as we've said. And it starts, by the way, and normally when you see something written, when they take one of the individual clauses, in isolation, it starts with, no person shall be deprived of, and then it goes down to, because remembering what the Bill of Rights is, the Bill of Rights. So if the body of the Constitution itself lays out the powers of the federal government, the Bill of Rights was a series of rules that presented further constraints on federal power. And that's an important point to make for everybody and for everybody to understand, right? That gets underscored in the 9th and 10th Amendments, which I know we're going to be covering later on. The 9th Amendment, which says that the enumeration of certain rights in this Bill of Rights isn't meant to deny the existence of others. And then the 10th Amendment, which says that anything that hasn't been surrendered to government is retained. Anyway, the point is These are constraints on government power. And remember that the founding fathers were very much afeared of government power, especially centralized government power. And I'm going to get into the 14th Amendment in a little bit because that's very important as well. But here, the five clauses are straightforward. It starts with the grand jury clause, which is this idea that serious crimes can't just be accused of, people can't just be accused of serious crimes willy-nilly. That if it's a capital crime or some kind of serious crime, something that is going to cause you to be like essentially a felony level crime, something that could cause you to be in prison for a long time, or something that could cause you to be hanged or otherwise put to death, it requires an added investigation, an added level of investigation beyond normal law enforcement. It requires that a grand jury, we all know what a jury is. A grand jury is a group of people that have been convened by a prosecutor. They're going to have evidence presented to them, and then they will determine whether or not the evidence rises to the level that the person should be indicted, otherwise charged with a crime. So again, one of the things we're going to get to in the due process clause is the issue of arbitrariness. So that's what the grand jury clause is all about. If it's serious, then there has to be another level of scrutiny that's given by the people to the charges that are filed. And we can get into in the question session the sort of the problems therein, but we'll hold off on that for now. Then you have the double jeopardy clause. This is the idea that you can't be tried for the same offense twice. And this has a couple of different important reasons. One of the most important being that the founders didn't want someone who was acquitted of a crime to then have the prosecutors come back and keep trying them for the same crime, because you could have a situation arise in which the prosecutor is so hell-bent on getting somebody that they would keep them in perpetual prosecution until they got the outcome that they wanted. So the founding fathers said, you know something? No, you get one bite at the apple. And obviously there are extraordinary circumstances that chip away at this right, having to do with rights of appeal and who asks for an appeal. But it's essentially means you can't be tried for the same crime twice. Then you have the self-incrimination clause. This concept of pleading the fifth, which we hear about, whether it's being in front of Congress or whether or not it's someone engaged in someone testifying in court or someone who is being questioned by the authorities. The idea is, and some of this had to do with the founders being concerned about evidence being gathered as a result of torture. But the idea was that you should not be forced to testify against yourself. That you have this right to remain silent, as noted by Miranda. And again, like everything else, there are situations. This is a right that has been modified, isn't the right word, but re-examined over time. To the question recently in a Supreme Court case, which is, if you have the right to remain silent, do you really have the right to remain silent? Which is a weird way of looking at it. Then we get into the due process clause, and essentially, and I'm going to get more in depth into what this means. But essentially, the due process clause is supposed to ensure that government proceedings, especially government proceedings that either serve to limit somebody's exercise of their rights or serve to expand government powers, to ensure that process is fair and just and open. And we'll get into specifics about that. Again, going down this route of constraints on government power. And in terms of, this is why I'm saying that the due process clause leads into, the other side of this, because due process applies in criminal proceedings, certainly, but also in government civil proceedings. You have a fundamental right to a due process. Again, we'll get into this in a second. And the final clause of the Fifth Amendment is the so-called takings clause, which says essentially government has the power to take private property, but there are certain things government has to do in order to satisfy the rights of the people before that property can actually be taken. And it has to be for public use. and just compensation has to be paid. And again, we're going to get to that in a moment because I want to leave plenty of time for questions here. So for me, as I've said, part of how I came to my values, free markets and limited government, was a real interest in the concept of due process. And seeing people for whom a process had been unfair. I always, growing up, had a real sense of what was fair and what wasn't fair. Was always someone who would speak out about those things. And working with my very first boss in DC. So I was explaining this before the seminar happened. My very first boss in Washington, DC was a former assistant attorney general of the Justice Department who happened to be blind. And I was his reader and personal assistant. I was literally reading the law to him. And a lot of the cases that we dealt with, whether or not they had to do with property rights or other things, had to do in some way, shape, or form with due process. Which is something that is enshrined in federal law in Section 42 of the United States Code. And generally, in terms of legal scholarship, you divide due process into two things: what is procedural due process and substantive due process. And substantive due process is very much up for debate, but let's start with procedural due process. What that means, it's not just that a procedure has to be fair, right? But also that the rights are protected. We'll get to this in a second. Procedural due process rights. A government procedure has to be accorded in a fair and just manner, and it is done in a way to ensure that a decision is not arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law. And I talk about it that way. That's almost a direct quote from something called the Administrative Procedure Act, which is the law that governs the administrative state, the regulatory process. So it's got to be fair. So what it means is that someone who is impacted by the decision has to be afforded an opportunity to speak, right? So a due process. You have to have your day in court. You have to be able to have your say in front of administrative agency. The agency or the governmental entity can't have come to a prejudged conclusion, right? So if you go before a government entity and they say, we've afforded you a process, a fair, we've let you come and speak. Well, if they've already decided what they were going to do before they come in, well, that's a violation of your due process rights. That essentially, they have to, and then they have to come to some kind of justification for their decision making, right? They have to show why. They have to show their math. They have to show their work, again, to demonstrate why they have come to their decision, to demonstrate that it's not arbitrary, capricious, and abuse of discretion or otherwise not in accordance with the law. But going further than that is the substantive issue. So you have procedural due process. That's what we laid out. But substantive due process goes a step further. And it says that even if the procedures are followed, right, even if government has, one of the examples I like to use is, let's say that a government entity wants to eliminate the right to self-defense. Now, the right to self-defense isn't enumerated in the Constitution, though it's probably encompassed by the Ninth Amendment, certainly encompassed by the Second Amendment. You can flip that. Certainly encompassed by the Ninth Amendment, possibly encompassed by the Second Amendment. I think it is. But if a government entity said, we're going to outlaw, all right, if the government entity says we're considering outlawing the right to self-defense, that even if they go through the motions of having a hearing, taking comments, coming and listening to people who'd be aggrieved, having a vote, sort of engaging in a record, and they still decide that they're going to outlaw the right to self-defense, well, one of the legal theories about substantive due process says that because the right to self-defense is a fundamental right, that is an essential aspect of being a free person in a free society, then that violates substantive due process. And again, there's a lot of debate over this, a lot of debate over, what the Ninth Amendment means in terms of unenumerated rights and how this plays in. And there's a push-pull. I mean, all of these issues are hotly debated. Incidentally, let me digress for 1 second. I was someone who was interested in constitutional issues in a very limited way. I mean, I was interested in due process issues, but not as a constitutional matter per se. And it wasn't until I started working for this visually impaired lawyer and I was reading constitutional law on a daily basis, reading the law on a daily basis, that I came to realize that there is a vibrancy. I mean, everybody who's participating in this webinar today, and certainly all of the scholarship winners from Constituting America understand this in a way that I certainly didn't when I was their age, that there is a vibrancy to these discussions and these questions and these amendments and what's in the Constitution. And so all of these questions are getting debated and discussed. So most importantly in all of this, the vast majority of the Constitution applies only to the federal government. That's very important to understand. Except for the 14th Amendment, not except for, but the 14th Amendment is an important exception to this. Because the 14th Amendment extends the Fifth Amendment's due process protections to people in states vis-a-vis state and local governments. So you can have a federal cause of action if a state entity violates your rights. And I'm going to get into the takings clause in a second, but I'll give you an example. I worked on a case years and years ago in which someone had owned the last piece of oceanfront property in a town called Pacific Grove, California. And he had every right to build on this piece of property. And the local government just kept keeping him in limbo for years because they wanted to buy his property and they couldn't get the money together. And because so essentially they just kept him in this administrative limbo, all hearings after hearings after hearings, until finally we said, you're violating this guy's substantive and procedural due process rights. And essentially, challenged it under the Fifth and the 14th Amendments to the Constitution under Section 42 USC. But that's true in many instances where you see state or local governmental entities violating people's individual rights. Invariably, a civil rights suit will be brought alleging a violation of due process rights under the 14th Amendment. That's why it was created. That's why it was ratified. Finally, because I want to get to the question section, of great importance to me, and I'm going to hold up the book because I helped my bosses write a book on this 25 years ago called Property Rights, Understanding Government Takings and Environmental Regulation, is the issue of the takings clause to the Fifth Amendment. Right. And the way I almost always say it is I do put the two of them together. The takings clause and the due process clause. No person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. So what it's saying is, and it's underscoring, government has the power to take private property. We've given government that power. Now, we can question the wisdom of that, and there is some wisdom in this, right? Government needs to be able to take private property in order to build roads or land for schools or public buildings or even parks. And we can sort of get into that as well in the question section. And they do it through a process called eminent domain or condemnation. And that's, and they can do this. They can condemn property provided that three things happen. Three things. One, that the taking is for a legitimate public use, right? And we can all go through what public uses are. Two, that a due process is accorded to the property owner. The property owner's got to have their day in court or in front of a hearing to say, hey, I don't want my property taken. Here's why it would present me with a hardship if you take my private property, right? And then three, just compensation has to be paid. And generally, the general legally accepted definition of just compensation is what a willing buyer would pay to a willing seller. And invariably, challenges to challenges to eminent domain, they generally focus on all three aspects or some aspect of all of those three conditions. So for instance, you'll get the question, is the use really for a public benefit? Right? What are public, or is it really for a public use? And unfortunately, Supreme Court precedent now says that if there is a general benefit to the public, that benefit constitutes a public use, therefore a taking is legal. And I'll give you a real quick example. A woman named Suzette Kelo. She was a nurse. She had a little a cottage on the Thames River in New London, Connecticut. The city of New London wanted to woo Pfizer Pharmaceuticals to New London for their new headquarters. Suzette Kelo's land sat on what would have been the parking lot for the Pfizer headquarters. So New London took the private property from her. And Suzette Kelo challenged and lost, because the Supreme Court said that because the property, the taxes that would be generated by this Pfizer headquarters would be greater than the use that Suzette Kelo was making of her land. Therefore, there was a public benefit. Public benefit equals public use. And I recommend a great movie called Little Pink House, starring Catherine Keener, which is all about this. The good work that people at the Castle Coalition, which is an eminent domain coalition that the folks at the Institute for Justice run, they're doing great work. So public use is one. Then there's a question as to what are called regulatory takings. Now, regulations, are prohibitions on activity. If you have a piece of land that you want to make a use of it, and a regulation doesn't let you make that use of it, can that constitute a taking? And I'm sorry if my dog's barking in the back. And the answer is yes. And there are lots of different tests and formulas that can be used. But essentially the idea is you get a statute like the Endangered Species Act of 1973, which, while it purports to protect endangered species, is really about protecting habitat for endangered species. So if you own a piece of property and it's discovered to be a habitat for an endangered species, the Department of the Interior, the Fish and Wildlife Service, can essentially prevent you from using your land. The question is, can that constitute a taking? The answer is yes. Then there's there's the issue of abusing the due process rights of a landowner. Again, as we were talking about with that Pacific Grove issue, right? You keep somebody in a process that is fundamentally unfair, designed to wear them down, to try to get them to sell or give up their property. And then finally, on the compensation side of things, there is something called condemnation blight. A government doesn't want to pay just compensation for a piece of property. Again, going back to the Pacific Grove thing, this didn't happen there. But imagine a piece of oceanfront property that, if you can build a house on it, is worth $1 million. The government entity announces that they're going to condemn it, or they're going to make it so nobody can use that for building a house on it. All of a sudden, the value of it plummets to less than $100,000. So you lose 90% of the value of the property. That's called condemnation blight. And again, it's a big issue. In fact, where I live in Virginia, it has become a big issue where certain nonprofit entities that engage in buying up land for conservation, what they will do is they will work with government entities to threaten condemnation. The property values on that piece of property tumble, and then the nonprofit Land Conservation Foundation comes in with a sweetheart deal, and they buy up the land for a song. And that's what happens there. So, with that, I think that sort of covers my overview. And I want to open it up to questions. You can tell these are issues that are very near and dear to my heart. So I'm happy to open up to questions.
Well, thank you, Andrew. And that's such a great overview, the Fifth Amendment. And there's so much in there. So yeah. Thank you for going through all of it. And just to recap, one of the things I thought was really interesting is until I got involved with constituting America, I never knew anything about the Fifth Amendment except for self-incrimination. Yep. I take the Fifth. But the way that you outlined it with the grand jury clause, the double jeopardy clause, the self-incrimination clause, due process clause, and then the takings clause, I'll never forget now, 5 clauses in the Fifth Amendment.
That's good. Yeah, absolutely.
Great. And now we have to come up with a good acronym to remember them all. But yeah, I'm going to turn it over to Tova, because I know Tova's got to get to class here in a few minutes.
Yeah, thank you. This was a really comprehensive overview. It's amazing how there's such a such a compact text, as the Constitution is the world's shortest written constitution, but there's so much in there and it's
That's the
so
beauty
long
of it.
lasting. Yeah, and so I guess one broad question to kick off is, I find it interesting the framing of shall not be deprived of life, liberty, and property, how
Yeah.
those three things are kind of considered to go hand in hand. So I'm curious if you could just explain sort of how the American founding fathers conceptualized property as tied to life and liberty, and how maybe that was deferred from or was a continuation of the British conception
Well,
of
sure.
property.
And it's interesting, right? Because remember, in the Declaration of Independence, the phrase is life, liberty, and the pursuit of happiness. And it's one of those situations where you can almost use the two interchangeably. But property was a very concrete thing, and I think that they tied the other aspects of it in the issue of liberty, the freedom to do, the freedom to act, right? But we could talk about positive versus negative rights. But the bottom line here is that property sort of encompassed the fruits of one's pursuits. So whether or not it was one's home or one's business, that's sort of where it encompassed. Keeping in mind that one of the great differences, obviously, between us and the former system was that we in America made it much easier for people to go and acquire property, and we sort of recognized a much greater aspect of the concept of ownership, including the concept of self-ownership. So that's where it comes in. But they wanted to be much more concrete, because in this instance, because you're constraining government and because you could encompass liberty in that pursuit of happiness, they wanted to make sure with greater specificity that property would be protected. And let's keep in mind that in the modern parlance, right, we are, we extend property not to just real property, i.e. real estate, land, but also things that have value. And then ideas, of course, we have this massive protection of intellectual property rights. So government can't come in and simply take something. I'm reminded of Iron Man 2, the Marvel movie, in which they were talking about using eminent domain to take the Iron Man suit away from Tony Stark. These are things that happen. And there was something else. I was going to say something about due process and property. Oh yeah. This is also why the concept of corporate personhood is so important, because there are many ways to get around the Constitution's other precepts. And I got into this with somebody on a particular talk show host who didn't believe in the concept of corporate personhood. And I said, okay, you don't believe in corporate personhood. Well, yes, you as a journalist have a First Amendment right in terms of freedom of the press. Journalists have a right in terms of freedom of the press. But what happens if, and obviously the government can't take away your right to speak, but what happens if the government doesn't like a particular news entity, they can just go and take their building, they can take their presses, they can take their computers, if we don't believe in corporate personhood. That's why these things are important. By the way, I want to point out something else real quick, Tova, because not just to differentiate between English common law or English statutory law, but also other constitutions. The Soviet Union protected, in all of their constitutions, the Soviet Union protected freedom of speech and freedom of religion. The one thing the Soviet Constitution did not protect was the right to hold and own private property. And so the government could threaten and take away the computers and buildings and printing presses and whatever of any kind of an entity or any person who was speaking out against. They wouldn't violate their speech. They could still go out, technically, I suppose, and yell in the public square somewhere. But if they couldn't print what they were doing, they didn't have the means to distribute what they were saying, then their rights were violated. That's why, all of these rights that are in the Bill of Rights, they all undergird each other and are interconnected.
Yeah, absolutely. That's a really great way of putting it.
Thank you.
And then just to get a little bit more into the details of the amendment, this idea of a grand jury, I know you spoke a little bit about it, but could you talk a bit more about what exactly is a grand jury and
Sure.
what just separates it from a regular jury?
Well, so a jury is something that is convened very specifically for a trial. They've got very specific rules. They've got rules of evidence that they have to uphold, right? You have to convict somebody beyond a reasonable doubt, and these are all criminal trials. And of course, my dog's coming back right now because my daughter left. But a grand jury is a different element entirely. A grand jury happens before anybody has been charged with a crime. In fact, their goal is to figure out if somebody should be charged with a crime. And so they have different rules of evidence, different things that can be introduced. Essentially, they are at the mercy of the instructions that the judge gives them in terms of how to look at the law. And I'll explain in a second how they get chosen. And then in terms of what a prosecutor decides to present to them. And so what happens is that you get summoned for jury duty, whether or not it is federal jury duty or local jury duty, and you can get summoned for both. And you will know when you show up at the jury selection process, you're being considered for a grand jury. And you get 12 people, and they can either meet, continuously, or they meet sporadically, but they're called together and they hear evidence from the prosecutor, and get instructions from the judge as to how to view that evidence in terms of the law that is being alleged. And if they believe that there is a likelihood that somebody could be convicted, now again, it's not beyond a reasonable doubt, it's just a likelihood of the possibility. And again, not seeing what the defense is going to say, they decide whether or not to present an indictment and give that indictment to the prosecutor, who then can go and arrest the person. And they can be formally charged. And so, it's one of those things, again, because the process is really one-sided, right? Obviously, you've got a jury, and they're supposed to be a jury of regular citizens. But the saying goes that a good prosecutor can indict a ham sandwich. A skilled prosecutor can indict a ham sandwich. So, you always keep in mind that someone is innocent until they're proven guilty. And that, just because somebody's indicted doesn't mean that they're necessarily guilty.
I see.
Yeah.
And then going on to, how a person can't be compelled to testify, against themselves.
Yes.
But what about, could you talk about the idea of a subpoena and what that is in regards to? Because I know it's been in the news a bit about people being subpoenaed and then being, sentenced or punished for not appearing for subpoena. So what's the difference between that?
Well, right. So if you get a legally issued subpoena, right? If an attorney goes before a judge and says, we want to get this person to testify, the judge issues it, you are supposed to testify. You have to testify. Now you could talk about whether or not, in terms of Congress, whether or not committees that are not legally constituted or lawfully constituted can compel you, but set that aside for a moment. The idea is you have to show up. You're required to show up, but you can not answer questions. And you can say, I am asserting my right against self-incrimination as outlined in the Fifth Amendment to the Constitution, and I am not going to testify against myself. It gets a little bit more tricky when you're talking about evidence and what you're compelled to send in. It gets even trickier with things like opening up access to your phone, opening up access to your bank accounts. And so there are legitimate questions in law. And I'm going to tell you right now, I don't know where the line is, frankly. I just know that this is being debated as to whether or not, to what degree you can refuse to submit documentary evidence as way of an assertion of your Fifth Amendment rights. Because, in this day and age, audio evidence, documentary evidence, video evidence, those kinds of things can be used to convict somebody, even if they don't testify even if they refuse to incriminate themselves. So the question is, as to what level does this protection against self-incrimination extend? Now, and I'm someone who believes that the rights against self-incrimination should extend as far as possible. There was a case 13 years ago, I think it was the Salinas case, in which the accused answered some questions, and that gets into a whole tricky area. Technically, if you assert your right against self-incrimination, you can't answer any questions. And sometimes you'll get prosecutors who will try to shake you on that by asking you your name or whatever. But they stood silent in answering other questions. And that gets into what I said at the beginning. Is the right to remain silent really a right to remain silent? Can you just sit there and say nothing? Or do you have to affirmatively say, I'm asserting my Fifth Amendment right against self-incrimination? And I think, to me, the right to remain silent is the right to remain silent. If someone says, you have the right to remain silent, then I'm going to say silent. But that's just me. So that's sort of where we go. But this is what I'm talking about in terms of the vibrancy. These questions, and it gets back to something I think you said early on, which is the Fifth Amendment. We have a short constitution, small constitution, not a lot of words, but with great meaning. And I said that's the beauty of it. The beauty of it is that it can be flexible, and we examine these questions given the circumstances over time. What does it mean? Is there a difference between substantive and procedural due process? One of the other things, I'm sorry, Tova, let me just add this, because one of the other questions that gets asked is the issue of overcriminalization, right? If someone gets charged with X crime, a prosecutor will charge them with a whole host of other things as a way of trying to get them to plead guilty or to get them on a lesser charge. And so what happens if they are acquitted of the lesser charge, but they were never prosecuted under the original charge? They can then be charged again. Or if something is a crime in both federal law and state law, and the state, I won't get political, I won't get in specifics, but there is a situation in which, something, I'll do it here. Someone was accused of assault at a local level, and the local law enforcement decided to not pursue the assault charges, but the case was politically charged. So the Justice Department decided to prosecute this person under federal law. And so the question is, how does that deal with sort of the issues of double jeopardy? Actually, the state inclined to prosecute. The state prosecuted this person and they were acquitted, but then the federal government decides to come in and prosecute them under the same set of fact circumstances, but a different crime. To me, that violates double jeopardy, at least the way I read it. By the way, it's not like in the really awful movie Double Jeopardy, which I don't urge any of you to watch. The woman is convicted of killing her husband, and then she discovered that her husband faked his death. And some lawyer in prison said, well, you've already been convicted of killing him. You can go kill him now, and it's double jeopardy. No, it doesn't work that way. It's a separate crime.
Good to know. There go my weekend plans. I'm just kidding.
Thanks. Yes.
But thank you so much for answering all my questions, and I'll now pass on to the next person. Thank you so much.
Wow, there's quite a bit in this amendment that affects our everyday life. It goes from property rights to our criminal court cases and civil 100%. Cases, everything. So what a broad topic, and really gets to the fiber of really civics and everyday American life. I didn't realize how tied together the concept of property was with how you would split up the clauses there, and how it goes right from your rights as an individual. You talked a bit about self-ownership into then your rights as an individual of owning property.
Yeah.
And so I had of course, a bunch of questions. So you talked about common law and Magna Carta. Are there any really big splits in the Fifth Amendment where the Americans came up with something, anything novel or change?
Well, I think the codification of this concept of due process and what it means is certainly it's different than the British common law system, actually affirmatively inscribed there. And then, I honestly, I have to say this, I don't remember the specifics about how the British do property rights, keeping in mind, as I'm remembering this in the back of my head, that under British law, the king or the monarch remains the owner of all of the lands in the nation. And that you have what's called a freehold interest, that you have the permission to occupy that land. And so ultimately the king has the power, or the monarch has the power to kick you off if the monarch wants to. Here we flip that around. If you own something, you own something. We can get into the history and, stolen lands or whatever, but the reality is
that's funny. That gets right into the eminent domain main part of it. So while we created this new system where you can own land and you're not just a what would you say, a freehold interest holder?
Freehold,
Something
yeah.
like that. Freehold interest. So the takings clause and for public and being able to take for public use. Why do you think the founders felt we needed that?
Well, I mean,
Why do you think they thought we
again,
needed that?
it gets down to things like being able to acquire land for things like roads and government buildings and military bases, things of that nature. They knew that at some point in time the federal government was going to need to do this. But they wanted to, again, make sure, again, getting back into the issues of the due process, right? They wanted to make sure that these decisions were not arbitrary and capricious. And again, that it can be used to punish somebody, right? You're a government official. You don't like somebody, so you want to make sure they get off their land. So you're going to abuse the process to get somebody out of their land. And there've been all kinds of fictionalized stories of these kinds of things happening. So the question then becomes, over the course of the next, what do we say? It's 1791, so 231 years it'll be this year, Kathy. 231 years, the definition of public use has changed dramatically. And it starts with, in the middle of the 19th century, because the government had an interest in the creation of a transcontinental railroad system, that they essentially ceded some measure of eminent domain power to train companies, railroad companies, thank you very much. I appreciate that. Sorry, the time. So they ceded some measure of power to the railroad companies to condemn land for these railroad lines. Again, a very weird central plot point in the movie Blazing Saddles. Everybody talks about how politically incorrect Blazing Saddles is. At the core of it, it's an eminent domain movie, and a property rights movie, weirdly enough. But the point is, so then it gets into questions of blight. I don't know if you know what blight is, but it's this idea of if a section of a city gets run down, what is the public interest in having that rundown section of a city torn down and replaced by newer and better housing? And so then it opened up this concept of the public benefit doctrine, that if the public is going to benefit from it, therefore it's a public use, therefore the taking is justified.
Seems pretty radical change of public use to public benefit.
That's exactly right. And so, it's funny because we get into this discussion of stare decisis, the reliance on precedent. And I've talked about this, and I've always said stare decisis cuts both ways. And there have been, opportunities in which the Supreme Court could show courage in overturning a previous decision, and opportunities in which or in situations in which they haven't. The Kelo decision was a prime example. The founders never envisioned a situation in which somebody's home would be taken for a very clear private benefit. Yet this is the way eminent domain law had come to over, at that point, about 220 years, 215 years. And so it opened it up, which essentially is why the concept of public use has been codified in a number of state government documents. A number of states have gone down that road. Again, I urge everybody who's interested in this to check out Institute for Justice and their Castle Coalition. This is all that they do. But it's fairly serious. When I was a lobbyist for small businesses, we were hearing about this. You're a small business owner. You want to find some place where property values are inexpensive, especially if you have some kind of an industrial use. You build up a customer base. And then because you're in a neighborhood in which property values are lower and it may be more industrial, somebody gets in their head that they want to solve the problem of urban blight. So they come in and they condemn your property and you're forced to move. And you may be paid fair market value for the land and the building, but not for the loss of your business, loss of your clients, the loss of your traffic, all of the things that are involved there. And so that's a huge issue on that side.
Yeah, it seems like, we obviously talk about the Constitution a lot. This this public use of this takings clause is one that I understand the founders seeming to think that the country would need, the government would need to expand to a point where it may need land, but it also seems like it's extended to exactly the opposite of this core concept that was life, liberty, and property. So it's kind of confusing. But one last question, because we don't have too much time, and I think you could talk about the property for at least an hour. So just about, when we're talking about substantive due process and the right to trial by jury, if when someone is found not guilty out of prison, I've heard of them then receiving some type of pay or settlement or something like that for the time they were in jail. But what about when you are accused of something, particularly like if it's at a highest level, like the DOJ or FBI accuses you of something, and your whole life's ruined and you're in prison for like 5-6 months before you go to trial and you're found not guilty, then is there some type of retribution for what you've lost?
It's very hard, and it gets into issues of sovereign immunity, right? Which is the ability of someone to sue. Even if you can prove that someone was a bad actor in the job that they were doing, because they are an agent of the government, they can't be sued in their individual capacity due to this issue of sovereign immunity. Then you've got to prove all kinds of things, like there was malice, that there was some kind of this is actually going on in Baltimore right now. It's been going on for a while. A number of different cases in which there are allegations of bad actions on the part of the Baltimore state's attorney, and so in some instances, you have to find a lawyer and you have to sue. Some lawyers are better at it than others, but like everything else, and if this is true with property rights, it's true with any time you decide to sue a government entity, especially the higher levels of the government, like the DOJ or the FBI. The higher the level of government, the more resources that government has to defend itself, and the harder it is for you to get your day in court. And I'm gonna actually turn it back to the property rights issue, the takings issue, because we've dealt with issues in which there have been these regulatory takings and they've been challenged, and people have filed lawsuits in either federal district court or the Court of Federal Claims, and it can take 12 years or more to get that case solved or settled. If you can stand up to the government has all the resources in the world to defend themselves, whereas your resources are limited unless you can find the attorney who's willing to take on the case pro bono, and there are some of those, but very few people can handle a lawsuit that lasts 12 years and may not end in success. And you're right, there has to be some kind of easier mechanism when someone's life has been upended unfairly by the malactions of a government actor.
All right, thank you very much.
You're welcome.
Maybe we can answer a couple of the audience questions.
Sure.
Yeah, thank you, Jewel. Great questions, and great questions, Atova. First of all, we want to give a quick shout out to the students that are on with us today. Terry Zalesnak has 3 homeschool students. Cami Wainhouse has a homeschool student. Katie Dice has homeschool student.
Hi, everybody.
And Tiffany Smith has up to 75 students from Hamilton County Virtual School.
Wow.
So we want to, in addition to our great audience that we have, we've got some great students on, and we want to tell the students how much we appreciate y'all being on with us today. So Andrew, Tracy asks if some of the COVID payouts that came about, during the time of COVID were a result of Fifth Amendment, if the Fifth Amendment was used to justify any of that.
Well, it depends on which kind of payments you're talking about, right? So essentially the government essentially gave a compensation to Pfizer, there were all sorts of exchanges that were going on. I have long said, and this is something that when you talk about the relief funds that went out there, this was not some kind of a propping up, and it's different than giving people handouts. The COVID, the loans that were given to small businesses. To me, I always said that the Trump administration, anybody who came after it, that they should be framing this as compensation under the Fifth Amendment, that these businesses were essentially being temporarily taken, therefore just compensation was owed. And it's a hugely thorny issue. When you think about the fact that our economy is $17 trillion in size, around $17 trillion in size. That's, every few weeks, months that you keep it closed, that's, trillions upon trillions of dollars here. So that's incredibly important. There was another part to this that I wanted to say about compensation. And I lost it. I'm sorry. So there you go. But yeah, so yes, I do view it in that way, as it should be. This is where I wanted to go. One of the problems that we have is that it's also established generally that if something is done in the name of public health or in the name of the police powers of the government, then the government doesn't owe compensation. But I think that can be sorely put to the test if the entire economy is shut down, right? If one business is shut down because of a public health emergency, there are different things that apply. It's a whole issue. It gets into the prohibition era laws and state prohibition laws. A brewer that got shut down in the 19th century, and whether or not the state had to pay just compensation, the Supreme Court ruled that they didn't. But I think that these are all things that should be revisited.
Well, thank you. And
Thanks.
Martha Jenkins says, glad to see another William and Mary alumnus.
Woohoo! Go Tribe.
And Muhammad Sarmad Atta asked for the name of the property right book again.
Oh, sure. I'll put it up here. I'm not sure if you can find it. You can look around for it. Property Rights, Understanding Government Takings and Environmental Regulation by Roger and Nancy Marzullo. They are now partners in their own property rights law firm, Marzullo and Marzullo. And they are the
Marzulla.
Exactly. Marzulla.
Okay.
And
Right.
I assisted in the writing of this book. There's a lot of my blood in there. It was also researched by a guy who's now a law professor at Emory named Sasha Volokh. He and his brother are the founders of the Volokh Conspiracy blog, which, if you're interested in law and policy, it's the go-to place.
Okay, and then a couple of comments from John McDonald. John McDonald says, property was prevalently taken from the colonists. There were no rentals. Property was all one had. There were no 401ks, no stock market. Property was a huge deal. Much of the Constitution is aimed at sufferings endured by the colonists at the hand of England.
Yes, and I appreciate that. That's my friend John Mark. I appreciate that, John. Thank you.
And then Dr. Braverman says, divorce courts frequently seize land, strip assets with forensics, court-appointed experts, friends of judge, administrative court, et cetera. Is that constitutional?
Well, I mean, I think it's different in a divorce proceeding because it's not the government that is necessarily engaging in this, but it's the two opposing familial spousal parties that are engaging in each other, and they're trying to figure out the distribution of assets. I mean, we can get into, I certainly, I think that's something that should be rightly figured out at the state level. I don't think the federal constitution has any, I mean, then you get into issues of due process. And I think it depends on how the process is afforded to the property owners whose property is being stripped and reassigned. But it's a great question.
Well, and that is, I think that does it for our questions. We've gone a little bit over time, and we just want to thank you so much for being with us today. And are there any parting words that you want to leave us with?
Listen, yeah, these are thorny issues, and again, they're always being chipped away at. I, as I said, this is why I've always been fascinated by these two. There's my dog again. Fascinated by these two aspects of the Fifth Amendment, specifically due process and property rights. Oh, and yeah, please go and check out the Institute for Regulatory Analysis and Engagement, instituteforreganalysis.org. And the new podcast is up. We're still doing Andrew and Jerry Save the World, but the Lunch Hour podcast is up on YouTube, also on Apple and Spotify. I think you need to look up Lunch Hour and Federal Newswire. Last week we talked free speech because it was Free Speech Week with Heather Lauer from People United for Privacy. So please go and check that out.
Thank you. And we did put
Always.
the link to your Institute for the Regulatory Reform in the Q&A, so everybody can. So thank you so much. And Jewel, thank you. Any parting words that you want to give us?
Just thank for this packed show, and hope everyone got a lot out of it. Hope to see you again.
Thank you. Well, y'all have a great week. Thank you so much.
Thanks, guys.
Bye.